right, that being the case then, the next case coming before the court here is Rivenbark versus Discount Drug Mart. Each party will have 15 minutes in which to argue their case. If you're the appellant, you may retain up to 5 minutes for rebuttal. Let me know when you come up to the podium. I'm keeping track of the clock and I'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you, Your Honors. Good morning.
Good morning.
My name's Cliff Rivenbark, and I'm bipolar. Last time, and I'm manic today. Last time I was in this court, and this is a joke, I was separated in half, and I left here cured because the court took my bipolar away. I have my opinions of how trial went and how fair it was, and I feel that I could have had a better, fair chance. I will start that, along with the bipolar, I am also diabetic. I eat well, try to exercise, take a lot of pills, but you know what? I'm not in remission. And that's a word you hear a lot in this case for the bipolar. It's called managed. I'm managing my own diabetes. Some notes were brought up about remission, and it was brought up by the judge a couple times, Mr. Cohen over here, an expert testimony for job placement used it a lot. And those are notes from a doctor, and maybe he should explain what that is. But for a brief second, my blood sugar may be perfect. And for a brief second, and my hands are shaking, a brief second, I may be in a bubble in a perfect world. And I go every 3 months to my doctor, and I try to have positive when I go in to see him in a comfortable environment. I would like to know how many times in the transcripts was bipolar used. Everybody talked about it. It was on every page. But by the end, the history was all wiped away. I don't want to talk about expert opinions at this time. I would like to say that everybody that testified knew I was bipolar. Sad part is only one person, Janet Sakara, HR director, knew from way back in school one little thing in a class that bipolar is high and low. To me, I would just like to read a few things. One I just pulled out of the newspaper today from, they're trying to get money for funding issue 4 in Lorain County. One thing in here, it basically says there's a conservative estimate that 20% of the population will suffer from mental illness at some point in their lives. I think I would just like to read these words generically. We are undereducated, we're uninformed. Similar to autism in the 90s, there's a stigma, there's fear, people think you're crazy, you're dangerous, there are stereotypes. They think about schools and malls with guns and bombs, and the big thing is you're postal and we're afraid of you. And I'm dealing with my disability and people seeing it but not quite understanding about my shaking hands.
Mr. Rivenbark, do you think that's part of the reason why they keep using remission instead of the word managed?
That would be a question for my psychiatrist, and he would be the only one to say what codes he puts in his record.
In your opinion, do you think that's why the word remission is?
I am never going to be cured, and I can be managed. I can say that I'm doing well, and whatever they want to say, I'm bad today. You can already see my hands. I didn't sleep last night.
Can I ask you a question too? Do you want to retain any time for rebuttal?
Probably not, because I'm a long-winded guy.
Okay.
But those people saw me from 2002. They said I was irrational, and I was accommodated to go to the warehouse. And then again, they tried using the 2012 that I I was still irrational. Well, that's consistent to me, and you may not know anything, but I've been the same the whole time. 100% the same, except the only thing is, you don't understand. And if you put me in a situation of great stress, like this, physical pain, which I can talk about, that amplifies it. My work history, quickly, I worked since I was 13. I was a manager at 1976, had a couple more manager spots before 1984, when I was a hiring co-manager for a grocery store. From 84 to 99, I was a manager. I went to Drug Mart in 99. I had some problems, and I guess I became stupid all of a sudden. I was bipolar, ended up having a diagnosis. They did accommodate me. Their human resource manager let me have a nice quiet meeting room, made a decision to go to the warehouse. I tried working. I had many things happen. I got a car accident, hit by a car, 2007, totally racked me up. I came back within the one day before company policy is, after the family leave, voluntary termination. So you have to be back. I made it a week. I had a problem. I went up to Lee Ring, told her, I'm struggling, I'm fatigued, I need help. I asked for ADA accommodations for job restructuring. We talked, and she said the only thing Discount Drug Mart does is FMLA. Well, I just got off of one and maxed it out, so guess what? I came back 3 weeks in a row. Third week I left there, and I know a little bit about ADA and what you can have as help. And I almost left there crying. The car accident, went to a different area to pull. I had some different problems where I would consider the torquing motion of stocking to be a problem on the leg that's got pins and plates and screws in it. Now, I'm not Tiger Woods. But I went to HR again and tried to get an accommodation and told her I felt I was being harassed, and to do extra work, I lost a helper from the heavy items. Well, there was a nice person there, Lisa Sartan. She gave me a letter that I wish she was compassionate and a nice person on paper, and I'd like to read a little bit of it, dated 12/5 of 08. She wanted to help me with a reasonable accommodation. I needed an assessment, current abilities. She went on to say, we're giving you a job description, and if you need or would like to view the job work site first. She was going to let my doctor come in to check the area and make arrangements. If further evaluations needed, they would take responsibility for time and compensation. In reliance with your opinion, company wants you to have the opportunity to gather all the information considered necessary, issuing your opinion in this important issue. I wish after that date someone would have accepted that as a company and helped me out.
Did you have a doctor go?
My doctor wrote many notes, and it was a lot of interpretation. My doctor finally is Dr. Wagner. He wrote a letter with his telephone number on it on December 8th, but here's the kicker: on January 27th of 11, he requested, in order to give you a better understanding of my patient's Rivenbark's limitation, I'll need a copy of the job description, please. Should you have any questions, please contact me at my office, and then his telephone number's on there.
Did you provide a copy of that job description to him?
I asked the warehouse manager in the past for the job descriptions, and he told me no. during trial, he had admitted he did not give the job descriptions out. Now, the human resource lady, that she puts the cart in front of the horse because she deals strictly with the doctor, not with a disabled person that needs advice.
Was there a copy of the job description attached to that letter?
At this point, yes, but I'm way ahead then, because I'm asking for a different time. They did not provide it after this point for the job I was doing or the next job. And although he needed that information, they failed to give it to her. She said that she thought she gave it to him, but she doesn't have a record of it. So basically, in the interactive process, they dropped the ball big time on this. I needed this help. I needed this because they wanted a letter. First time I talked to her, she said, I just need a letter from your doctor. Second, it wasn't good enough when I brought it back in. Second time was, I need a letter, he knows what to write. Wasn't good enough. So I'm wasting my time, and I call it the merry-go-round, or like government work. And this went all over the place. I can't really talk too much more on that. I'll get to Lee. Lee, I already told you that we had that conversation when I came back in early '08. I saw her 20 to 25 times over the course, and there was not a problem. Last couple of months, she said she saw me 3 times. I say 7. She didn't get intimidated until the last day. I, during that time period, was out for exasperated bipolar. So I guess, that might mean something to somebody. I missed a lot of work, but mostly it was personal time and vacation time. I burned it all off. And they put the big plaque up there saying I missed half of the time in the world. Well, FMLA shouldn't really count in there. And for disciplinary, it takes 5 points to be verbal warning. I had half a point on July 6th. So there's a big map up there saying I'm never available. Hey, every time I got done early, I volunteered to go home. Boom, I was out the door. Now with Lee, I went into the meeting. It wasn't a half-hour meeting, it was less. I read a 2-page letter to her that I had handwritten. She had a 4-page narrative. Oh, the week before, I needed a meeting and set up a meeting with Human Resource Director Janet and Lee. August 2nd. They were both there at 9:20. I told them my new job that you put me in is killing me. I said it twice. I talked about my bipolar acting up. I talked about not sleeping at night. And I offered 6 options and said my doctor will be back in 2 weeks. They're trained to take notes. Neither of them took any notes and don't remember what happened in the meeting. When we were in this meeting upstairs with Lee, she wrote that narrative, and I'd like to be on the stand and read it line by line and tell somebody the truth. It is so fabricated. The first time she said the word restriction, I reminded her about the meeting we just had the week before, explained it all, told her that my doctor will be back this week. This job is killing me, she amplified in the letter, and that's a little bit correct. But she used those words like 5, 6 times a piece in a 4-page letter. That to me is humorous. That is ideally fabrication. If I am talking to you on 8/2 and you know what's coming, why would you address, there's nothing in the file, no restrictions, no limitations, no accommodations we've always given you? I didn't come up there to talk about that. And it looks really nice. There's a lot of discussion from other people that you would not say the same as you in the trial. Everything was not quite right. So I would like to sit on that stand and say, both of you are not right. This is what the truth is. I never once heard about intimidation at all until my deposition.
Got about a minute left.
I went to an EEOC hearing, spent a lot of time there, and it was never addressed in the EEOC. Their claim was interactive dialogue. I faltered. John Gantz is president. He said in a meeting I had with him that he would be consistent with the company policy during that meeting. Well, the binder for the company policy was dated 9/29/14, 2 years after I left. I have 2011 and I have 2012, but it's revised and different. And for the most part, I think on certain pages that the court was protecting him, because I knew where the question was going, is did you follow company policy?
Okay, we will go through the entire transcript, so we'll get there, but you've run out of your time.
Okay, but the honest belief defense doesn't require full investigation. That was on 1092.
Well, we'll go look into that. I promise you we will scour.
I thank you for your time. I really didn't get to talk about as much as I'd like.
15 minutes isn't very long.
Thank you very much.
Thank you.
I would hope that I would have an opportunity. I didn't get to throw my lawyer under the bus. I did not have any witnesses, no expert witnesses. My doctor was never called, so I was my only witness being...
Then we'll be reading that, so thank you very much.
Thank you.
Thank you.
May it please the court. My name is Max Dane. I'm a lawyer with Cabbage Familo in Cleveland, and I actually tried this case. I'm here with my partner, Mike Ohan, who tried the case with me. Before I start into my argument, I want to address a few things that Mr. Rivenbark raised. First of all, Discount Drug Mart had an employment relationship with Mr. Rivenbark since 1999. Discount Drug Mart extended itself as a business and as people to accommodate Mr. Rivenbark in his difficulties over the course of 13 or 14 years. Mr. Rivenbark struggled in every position that he had. When it came to Discount Drug Mart's attention in 2002, Mr. Rivenbark was struggling with the psychiatric issues that he struggled with. Discount Drug Mart didn't throw anybody under the bus. They provided him a home in the warehouse operations that they had. Mr. Rivenbark was at that time trying to succeed as an assistant manager in the stores, and he was struggling. When it became clear that the bipolar issue was an issue and it was brought to Discount Drug Mart's attention in 2002, he was provided that accommodation. He never requested, nor did anyone ever tell Discount Drug Mart after that that further accommodations were required with respect to Mr. Rivenbark's bipolar condition. There's no stigma, there was no fear, there was no treating of Mr. Rivenbark as someone to be avoided or to shunned or anything like that. Mr. Rivenbark just explained, and he explained truthfully, that over the course of the years, he met with Lee Ring probably 20 to 25 times. There were times that they had confrontations, that they had issues, but Ms. Ring never treated Mr. Rivenbark with anything less than professional respect, and I think the record demonstrates compassion. It wasn't until the final 2 weeks of Mr. Rivenbark's employment, as his behavior and his conduct deteriorated as a result of his own perception that he had been demoted, that these meetings with people became confrontational and finally frightening. The jury heard 9 witnesses. The transcript is comprised of 1,768 pages over 2 weeks. And the jury determined that Discount Drug Mart terminated Mr. Rivenbark's employment because of his confrontation with Lee Ring, which left her frightened, shaken, and afraid. She shared those feelings with the people that she worked for, they investigated, and they made their decision. The factual question that the jury was faced with was simple. one of conduct versus accommodation. In other words, Mr. Rivenbark claims that he walked into Lee Ring's office on August 9th of 2012 and read a two-page letter, and he testified that he spent maybe 5 minutes in that room. Lee Ring testified to a half-hour confrontation, again, during which she became frightened for her own safety, during which she asked Cliff to recognize the fact that she was afraid of him now. And the jury heard those two, the juxtaposition of those versions, and the jury rendered its verdict as a jury must. There are at least 3 issues that I had hoped to get to, and I understand 15 minutes goes by quickly. But first of all, with respect to an understanding or a lack of understanding of Mr. Rivenbark's bipolar issues, Mr. Rivenbark's lawyer explicitly waived the issue of excluding bipolar and the bipolar condition from the evidence in this case. And they try to make an issue of whether Dr. Singh's records should have or should not have been admitted. There again, Mr. Rivenbark's attorney waived that issue. And by the way, it was their choice to not bring in an expert, that if they wanted to establish some causative relationship between Mr. Rivenbark's misconduct on August 9th of 2012 and his bipolar condition, that required expert testimony, and it wasn't there. They brought in Dr. Singh, who was Mr. Rivenbark's treating psychiatrist, only as a treating physician, only as a fact witness, and thus his testimony was appropriately constrained. We never had the opportunity to cross-examine him as an expert, to depose him as an expert. He wasn't introduced as an expert. So there was no, there wasn't the, you couldn't establish the linkage between, again, the purported condition and the conduct. Second, Discount Drug Mart's expert, Janet Kilbane, testified absolutely.
Can I interrupt you for a minute?
Yes, sir.
Is there a difference there because the doctor was a psychiatrist rather than just somebody with a family practice doctor?
There's not a difference as far as the evidentiary rules go, as far as the application of Rule 702 or 703.
Because he was not identified as an expert.
That's exactly right.
All right.
Yes. And again, Mr. Rivenbark's counsel embraced that and agreed with it and waived whatever issue there might be to raise.
His argument is the court already made the decision.
I'm not sure that I understand that argument. Mr. Rivenbark did not bring Dr. Singh to testify as an expert. As with most trials, there's a litigation calendar. This is when you're going to identify your experts. That gives the defense or the plaintiff, whoever, the opportunity to cross-examine them, for the opportunity to test what they're going to come in and tell the jury. He was not so identified. And that wasn't an issue at trial. They never argued that they should be allowed to introduce Dr. Singh's testimony as expert testimony because they recognized that they hadn't done that. They brought Dr. Singh to testify with respect to certain facts arising from his direct treatment that he could explain to the jury, which he did.
Would you have to say that from the time you first Discount Drug Mart had a relationship with Mr. Rivenbark, there was an awareness that he had bipolar disorder?
No, I would say that from the
beginning?
No, and I won't go outside the record. He struggled in his various efforts. When I say various efforts, he tried to be an assistant manager in their management training program at 3 stores in the late 1990s through the early 2000s. And he was really struggling. He was failing. And he was going to be let go. And then Discount Drug Mart received communication from Dr. Singh, who was his treating psychiatrist at that time, explaining that Mr. Rivenbark was struggling with bipolar issues. Now, there's evidence that didn't get in because, and I think it's appropriate for me to jump into it with much depth here, but Discount Drug Mart gave back to the record, reached out to Mr. Rivenbark. Mr. Rivenbark himself testified to this and made the opportunity available to him to A, either continue as a trainee in the management program, or B, take a position in the warehouse, which in or around 2004, I believe, he took. And for several years, he worked. And for many years, for 8 years, He worked in the warehouse, and again, repeatedly over time, received accommodations. He was badly injured, as Mr. Rivenbark just referenced, in a unrelated automobile accident. When he came back to work, there was evidence presented that they sent out an email, said, "Cliff, welcome back." And they gave him the accommodations that he required with respect to what it took to kind of, enable him to take his rest periods or do whatever it was with respect to the kind of the issues arising from the leg that he injured in that accident. So again, it wasn't until toward the end, I'm going to jump forward just a second. So beginning in 2012, the beginning of the year, through the summer of 2012, Mr. Rivenbark, for unrelated reasons, missed about half of his days at work. He was in a position, what we call an order selection position, where you are one individual who's charged with looking at an order sheet in the Discount Drug Mart warehouse and taking items off of about an 80-foot long bin, which will then be packed and delivered to the appropriate store. You're the only guy in that space. So there are a number of aisles and a number of bins, but each aisle, his was I think D4, at any rate, each aisle has only one individual. So when he missed, again, about half the days through the first half of 2012, Larry Hajarski, who was his supervisor, testified, I had to make a move, I had to do something.
Counsel, he indicated, and I noticed this in the brief too, that the majority of that time was FMLA leave.
I don't think that that's accurate. I think some of it was FMLA leave. And again, no one ever questioned his right to take FMLA leave.
Well, you have to have a position waiting for him when he returns with FMLA.
Yeah, but that was not an issue at trial, Your Honor. I mean, this was not about whether Discount Drug Mart appropriately or inappropriately supported his leave, because there's no question that they did. And he took 12 weeks of FMLA leave, but he also had numerous days of where he chose to punch out early. He had numerous days that he just wasn't there. And again, this wasn't casting fault upon him. This was explaining why he couldn't stay in that position. And even with FMLA leave, if I can step outside of the facts for a second, the accommodation has to be reasonable such that it doesn't impose an undue burden on the employer. And in this case, they couldn't function with someone who was only there half of the time. But setting that aside, it wasn't just about FMLA leave. And again, I need to stress that was not an issue in the lawsuit.
What was the record in trial in regard to him punching out early? Was it because they completed their task early and they were allowed to leave?
We didn't go into much depth. What we did was that in order to understand why it was that he was transferred to the loading position, which was his final position, was simply an accumulation of early punch-outs. Basically, Discount Drug Mart allows you to take what we call instant vacation. So he would just make a decision that he was going to leave that day at 2:30. Or he would simply not come that day because he would take what's described as an instant vacation day. I mean, again, he worked within the confines of what Discount Drug Mart permits in terms of, and he wasn't terminated, he wasn't suspended, there wasn't anything like that. But I can't answer your question specifically in terms of the underlying reasons for those early departures. And I have to stress, in the, whatever it was, 9 days of trial, that wasn't much of an issue, except to explain why he had been transferred to what we call a staging position. Now, upon transfer to the staging position in late July of 2012, Mr. Rivenbark took that as a demotion, and he was angry. And over the next 2 weeks, he had increasingly hostile and angry confrontations with supervisors and with HR people. And that is really culminated in his confrontation with Lee Ring, who was an HR official charged with sitting in the warehouse on Thursdays for 1 hour to meet with people as they needed to meet. So she had, because of these last 2 weeks of Mr. Rivenbark's kind of rising confrontational anger, she had actually made plans and testified to this as to what she would do if she felt trapped in that there's a room where she spent an hour on each Thursday. And she testified to the fact that she had actually kind of planned an escape route from that room if she needed it. And when the president of Discount Drug Mart heard that that was true, in the course of investigating the confrontation that occurred on August 9th, that was an important factor for him. That he had an HR person who felt afraid to take this meeting with Mr. Rivenbark and felt afraid of the potential consequences. And by the way, again, the jury heard Mr. Rivenbark's version of this confrontation, the jury heard Lee Ring's version, but they also heard how Discount Drug Mart reacted when they were provided with this information. Bob Waugh, who was the supervisor of the warehouse, saw Lee Ring immediately following the confrontation. She came downstairs, and both Lee Ring and Bob Waugh created contemporaneous records of what they saw and what they experienced. Bob Waugh described an employee who was shaken, tearful, afraid, and literally fearful for her life. Now, Mr. Rivenbark's counsel made much at the trial of trying to discredit, as you would expect, Lee Ring and saying, well, you overreacted, or well, you should have known. Again, Lee Ring interacted with Mr. Rivenbark professionally and without prejudice since 2008. It wasn't until these last 2 weeks when he became angry with what he perceived as a demotion that relationship changed. She took precautions after this happened, which included asking her husband to come and sit in his car as she left the job without making it known that it was her husband, and then following her home because she was afraid. She asked one of the officials at Discount Drug Mart, Buddy Graff, who's one of the things that Mr. Graff is in charge of is their security, to run Mr. Rivenbark's license plate so she knew where he lived so she wouldn't go near his home. She was afraid, and that's what Discount Drug Mart reacted to.
And all that's in the record.
It is.
Okay, and with that, sir, you're over time.
Shucks, thank you very much.
Okay, but we will review the record and look into that as well. So thank you both for your presentations today. We will take the matter under advisement and issue a written decision, which we posted to the website, mailed to both sides.
Thank you.
Thank you both for your
Thank you.
presentations.
Thank you.